Following the passing of the anti-homosexuality law by the President, Odoi West Budama Member of Parliament, Opiyo, lawyer, Kintu Nyango Ugandan Ambassador to South Africa, along with Mwenda, Sylvia Tamale, a law professor at Makerere University and others, filed a petition in the Constitutional Court challenging the law. The case was filed against the Attorney General, Pastor Matovu Ssempa of Makerere Community Church, and Engineer Langa of Family Life Network. In a ruling read by the Deputy Chief Justice Richard Ibutera, the panel of the 5 justices of the Constitutional Court declined to nullify the act, stating that it upholds the norms, culture and religion of the country, which must be respected.
It follows then that conduct that deviates from the cultural manifestation of any life, language, literature, music, religion, traditions, and customs operates at cross purposes with the right to human dignity. The notion of an individual's unfettered sexual autonomy defies the logic of offenses like incest, bestiality, and other natural offenses that are still on our statute books.
The court also viewed that the enactment of the act was aimed at protecting children and the vulnerable members from the acts of homosexuality, asserting that the Parliament didn't violate any of its rules in passing the law.
That limitation on the right to non-discrimination is proportional to the child protection objective of Anti-Homosexuality Act. It is demonstrably justifiable in a free and democratic society as envisaged under Article 43(2) of the Constitution.
Justices also highlighted concerns about the physical harm caused by the anal sex, especially to males, and its implications on the government's health care budget.
13.7 of the ANS in Kampala, Uganda, were found to be living with HIV. Anal sex causes physical harm. HIV infection represents serious harm to physical and mental health.
Whereas the court found that the rights to privacy was not infringed upon, the mandatory reporting provisions infringes on some of the rights. Court also dismissed allegations of infringements on the rights to freedom of expression and association, arguing that those freedoms are manifested verbally or in writing, as indicated in the Constitution, not through sexual expression.
We do not find the impeded sections of the Anti-Homosexuality Act to authorize unlawful entry onto or such interference with a person's body, home, or other act, correspondence, or communication.
However, the court decided to strike down Section 319(11)(2) due to their prohibitions of access to housing and medical care, which could subject individuals to mental health issues and inadequate standards of living.
We take the view that the reporting obligation under Article 14 would indeed have a chilling deterrent effect on access to health care by homosexual patients.
Despite declining to nullify the entire anti-homosexuality law, since the case was a public interest case, no orders were made on costs. After receiving the decision, the petitioners vowed to appeal the decision in the Supreme Court.
How can a judge make a judgment on such an important matter based on public sentiment rather than on the Constitution? Not once has one human being been arrested for recruiting children into homosexuality.
So it is really an attempt by the court to throw some things at the public to try and ameliorate what I think is a very poor judgment.
However, the respondents in this matter expressed joy at the court's ruling.
To me, it was a perfect moment in court to interrogate Pepe Onzima. How much did she spend on getting a sex surgery? Not only that, they must have a lifetime of hormones, they must have a lifetime of gels.
Homosexuality destroys individuals, homosexuality destroys families, homosexuality destroys society.
Deborah Nama Mwenda, UBC News.